Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Gujarat ROC Adjudication Order dated 14th March 2022 for the violation of Section 82 of the Companies Act in the matter of the Sri Nidhi Safe Vault Private Limited. In this case, company name Sri Nidhi Safe Vault Private Limited having registered office at Gujarat, and facts of the case that it is observed from the NCLT order in the matter of the arrangement between Sri Nidhi Safe Vault Private Limited, demerged company, and Lakshmi Narayan Safe Deposit Vault Private Limited, resulting company. It has mentioned therein that applicant demerged company does not have any secured creditor as on 28 February 2021. However, as per the MCA portal record, demerged company does have two secured open charge ID in favor of the two charge holder, the Cosmos Cooperative Bank Limited and SBI, amounting to 27 lakh and 30 lakh respectively. Therefore, it is revealed that the demerged company has failed to file satisfaction of the charge in pursuance of Section 82 of the Companies Act, read with the Rule 8 of the Companies Registration of the Charges Rules 2014. In this case, Regional Director Ahmedabad has issued instruction that it is observed from the NCLT order that the demerged company does not have any secured creditor as on 28 February 2021. However, as per the charge index available on the MCA portal, the demerged company is having two secured creditor or charge. The details given as ID and name of the secured creditor, date of the creation of the charge, and amount. Directorate has stated in the forced letter that it appears that the applicant company have not made compliance of Section 87 of the Companies Act. Directorate has further instructed to take appropriate action in accordance with the Companies Act and submit action taken report. Let's see the legal provision of the company law. As per the Section 82 of the Companies Act, a company shall give intimation to the ROC in prescribed form of the payment of or satisfaction in full of any charge registered under this chapter within a period of the 30 days from the date of such payment or satisfaction. Further, provision provide that registrar may, on an application by the company or the charge holder, allow such intimation of the payment or satisfaction to be made within a period of the 300 days of such payment or satisfaction on payment of such additional fee as may be prescribed. Further, Rule 8, Rule 1 of the Company Registration of the Charges Rule 2014 provide that a company or charge holder shall within a period of the 300 days from the date of the payment or satisfaction in full of any charge registered under this chapter 6 give intimation to the same to the registrar in form CHG 4 along with the fee. Further, subsection 86 of the Companies Act provided that if a company is in default in complying with any of the provision of this chapter, the company shall be liable to a penalty of 5 lakh rupees, and every officer of the company who is in default shall be liable to penalty of the 50,000 rupees. Further, if any person willfully furnishes any false or incorrect information or knowingly suppresses any material information required to be registered in accordance with the provision of Section 77, he shall be liable for action under Section 447. Further, Section 87 of the Companies Act provide that the central government, on being satisfied that the omission to give intimation to the registrar of the payment or satisfaction of the charge within the time required under this chapter, or the omission or misstatement of any particular in any filing previously made to registrar with respect to any such charge or modification or with respect to any memorandum of the certification or other entry made in pursuance of section 82 or section 83. But accidental or due to inadvertence or some other sufficient cause, or it is not of a nature or to prejudice the position of the creditor or shareholder of the company, it may on the application of the company or any person interested and on such terms and conditions as it deems just and expedient, direct that the time for the giving of intimation of the payment or satisfaction shall be extended, or as the case may be, require that the omission or misstatement shall be rectified. In so-called notice, reply and personal hearing, the presiding officer submitted that upon non-compliance of the provision of section 82 committed by the company and in compliance to the instruction received from the learned regional director, an education notice dated 17th September 2021 was issued to the company and its officer in default for violation of section 82 of the Companies Act. The company, by letter dated 4th October 2021, has replied that there is two charges. One first charge in the favor of the Cosmos Cooperative Bank Limited for 27 lakh in respect of the charge as collateral security for entire credit facility availed by Mr. Hari Krishna Les Technology and Sri Nidhi Retreats as disclosed in point number 12D of Form 8 at the time of the creation of the charge. The company has further mentioned in its reply that the charge 2 in favor of the SBI for 30 lakh rupees in respect of the immovable property offered as security to secure facility granted to the Sri Hari Laser, a partnership firm, and same is also disclosed in the Form 8 in point number 4A. The company further submitted that it is clear that the charge have been created for securing the financial facility availed by the other parties and as required since the charge was created on asset of the company and the same was registered as required under the Companies Act 2013. However, since no loan has been availed by the company, the amount of the secured loan in the balance of the company is nil. In the aforesaid reply dated 4th October 2021, the company has requested to grant an opportunity physical appearance to clarify the matter. Thereafter, a written notice dated 12th January 2022 were issued to the company and its officer in default as per section 454 subsection 4 of the Company Act, and a hearing was fixed on a scheduled date. Representative of the company appeared and attended the hearing proceeding and submitted oral submission along with the copy of the board resolution dated 22nd January 2022 for his authorization for appearance in the matter. The authorized representative submitted that in the company there is no secured creditor. The charge shows under index of the charges on the ministry website are contingent liability for the third party, Mr. Hari Krishna Laser Technology and Sri Nidhi Retreats and Sri Hari Ledger, a partnership firm. So Honorable NCLT mentioned that the demerged company does not have any secured creditor as on 22nd February 2021. The authorized representative has further submitted that no secured loan has been disclosed under the head Secure Creditors in the balance sheet file under the MC21 portal. During the hearing, the presiding officer responded that in the balance sheet as at 31st March 2019, the company had disclosed secured deposit for locker under the head long-term borrowing amounting to 3.33 crore and further observed from the E-Form MGT7 annual return for the financial year 17-18, 18-19 and 19-20 that the company had disclosed secured loan amounting to 3.12 crore and 3.33 crore and nil respectively. The authorized requested to adjourn the hearing on the next date for the submission of the case material, papers, document relevant to the matter of the adjudication proceedings. Thereafter, information of the next hearing has sent to the company corresponding email address dated 31st January 2022 to provide final opportunity in pursuance to section 454 subsection 4 of the Companies Act. But none of the representative of the company or director have appeared on the date so fixed. Hence, as per the Rule 3 of the Company Adjudication of the Penalty Rules, the matter is being proceeded with in the absence of such person. Presiding officer has submitted that as per the MCA 21 portal record that the company was filed two Form 8 for the creation of the charge. First Form 8 has a file online mode in this office in favor of the SBI, creation dated 28 September 1998, offering security to the secured medium term loan of 30 lakh facility granted to Sri Hari Leisure, a partnership fund. And second charge creation was filed on MCA portal by the creation dated 27th November 2008, amounting to 27 lakh for term loan of the 13.5 lakh sanction to the Sri Nidhi retreat, repayable in 60 months. Cash credit limit 3.50 lakhs sanction to Sri Nidhi retreat, and cash credit of the 10 lakh sanction to the Hare Krishna Leisure Technology repayable on demand, subject to review within 12 months. The presiding officer further submitted that it has been revealed that the balance sheet and financial statement from the financial year 2008-9 that the company disclosed under the note of account for the period 31st March 2009 that there is no contingent liability as on date. Further, it is observed from the financial year 2009-10 to 2013-14 the company has not given any disclosure regarding any contingent liability for the aforesaid financial year. The company has mentioned that the provision involving a substantial degree of the estimation in measurement are recognized when there is a present obligation as a result of the past event, and it is probable that there will be an outflow of the resources under the clause provision contingent liability and contingent asset. However, no information or details of the contingent liability provided in the financial year 2009-10 to 2013-14. The presiding officer submitted that it appeared that the company has created both the charge ID for creation of the charge in 98 and 2008. However, failed to file satisfaction of the charge in pursuant to section 82 or 87 of the Companies Act 2013. Also failed to disclose the aforesaid in the balance sheet and financial statement for the financial year 2019 to 2020-21, except in 2018-19 and 2019-20, whereas as per the details entered in the Form 8, the aforesaid secured loans were sanctioned for the repayable in the 60-month. Cash credit limit of 3.5 lakh sanction to Sri Nidhi retreat and cash credit of the 10 lakh sanction to the Hare Krishna Leisure Technology repayable on the demand, subject to review within 12 months. The object of the filing updation of the index of the charge through prescribed e-form CHG4 by the company with the public domain is in the public interest to enable the investor, public, and whosoever interested in the company can access the fundamental information about the company. Non-filing of the satisfaction of the charge e-form under the MCA portal will result in denial of the information to public about the company. Hence, the submission of the company and authorized representative does not sustainable in the matter. Under the above circumstances, the undersigned has reasonable cause to believe that the company and its officer have violated the provision of Section 82 of the Companies Act as noticed from the MCA portal record. In view of the facts and narrated above, the company and its director officer in default are liable for penalty as per Section 86 of the Companies Act. Accordingly, presiding officer is impose penalty on the company. Company is not a subsidiary company. However, the paid up capital is the 5 lakh and turnover is the 64.63 lakh as on date of 31st March 2021. But company has one subsidiary company, but therefore company is not fall under the ambit of the small company. Therefore, the imposing lesser penalty as per the provisions of section 446B of the Companies Act do not apply to the company. Therefore, penalty commensurate with the aforesaid failure, there is the amount of the penalty imposed on the company, that is the maximum, that is 5 lakh on the company, and on the 3 director here, on the 50,000 on the each director, that is total 6,50,000 on the total penalty imposed for the failure to comply of section 82, 83, and as per section 87 penalty is imposed here. The noticee shall pay the amount of penalty individually for the company and its director out of own pocket by way of e-payment under the pay miscellaneous fee category in the MCA fee and payment service within the 90 days of this order, and challan SRN generated after payment of penalty through online mode shall be filed in the INC 22 to this office. Appeal, if any paper, file appeal within the 60 days from the date of the receipt of the this order in form ADJ setting for the grounds of the appeal and accompanied by certified copy of this order. Thank you so much for watching this update. This is the case of violation of section 82 of the Companies Act, that is failed to report a satisfaction of the charges within the prescribed time period. Thank you so much for watching this update.